Hi everyone. My name is Frekhtman and I'm a personal injury trial lawyer here in New York City. And today I wanted to answer a frequently asked question that a lot of people are asking, and that is, what are the odds of winning my medical malpractice lawsuit? Well, to start, it's very important to point out that unlike a car crash or a trip and fall, a medical malpractice case usually does not settle. And that is because the insurance carrier that is representing a doctor needs to obtain that doctor's consent to settle. So for example, the insurance company could receive overwhelming evidence that there was malpractice, that this doctor made a horrible mistake and it led to devastating injuries. But for whatever reason, perhaps pride, ego, or greed, the doctor says, I don't want my premiums to go up, or I'm holier than thou, I didn't do anything wrong and I will not consent. And then the insurance company simply cannot pay a victim because they need that doctor's consent. And so the case is forced to go to trial. So what are the odds of winning? Well, it really depends. It really has to be a deep dive into your individual case, and you have to get all the medical records. That's the first thing. And you have to have those medical records reviewed by an experienced attorney, but also by an experienced nurse or an experienced doctor in the same community and in the same field of practice that can then be an expert and tell you whether there is malpractice. And that expert will give you an opinion as to merit. And under New York law, you have to consult with a doctor and you have to get that certificate of merit before you file a lawsuit. So that's one of the requirements. And one of the things we see with medical records are sometimes a client will tell us X, Y, and Z happened, but then when you get the medical records don't show that. So there can be a disconnect between what the client tells us happened, or their version or their understanding of what happened, and what actually happened in the medical records. But there are other possibilities as well. Sometimes we get the medical records and the medical records have something in them that is so exculpatory, right? It's almost like a notation after the fact that completely takes the blame away from the doctor. But then a deeper dive and a proper case workup shows us that that was actually a cover-up. That was actually written in after the malpractice and the mistake happened in order to, justify or explain another reason, like blame the plaintiff or whatever other reason. So that becomes almost like a frivolous defense. And sometimes we can find something like that, we can then use it against the doctor, the hospital, to really show and get the jury mad, and then you can get a really big medical malpractice verdict. So when that happens, that's something that plaintiff lawyers like me love to see, because you could really get them for doing something like that. That's corrupt conduct that sometimes leads to punitive damages. So what is it really based on? It's based on the lawyer workup, the case workup. Like, I was reading a lot of books, some of them from trial guides and other lawyers all over the country. And it seems like some of the top verdicts, like one lawyer was getting a verdict like $50 million. And then when you read the write-up, because in the book, they really describe the case, it really happened because the workup was so pristine and it was so detailed and meticulous, and he just went into every nook and cranny and every possibility. So there was no chance of surprise, and there was no chance of that lawyer didn't uncover something. So they really go deep. And what that means is, for example, when you're doing a medical malpractice case, you may question the doctor, and the doctor may just deny everything. But then what you could also do is question another independent witness, like a nurse who was in the operating room, or if it's a nursing home type case with abuse, you can question other people on the floor, other nurses. You can question other doctors. Some doctors don't work for the hospital, some are independent. So and now in New York, we have what's known as 30B6, which is issue designation. So you can tell the entity, like a hospital or a corporate entity, a medical practice, you could tell them, hey, these are the topics I want to talk about, and they have to produce the person who will bind that corporation. So that is very powerful as well, because before you could just get people saying, well, I don't know, it wasn't me, and there's no accountability. But now, if the answer is, I don't know, well, that means that ABC Hospital doesn't know, and that's your official position in this litigation. And then at trial, you could say, well, they'd say they don't even know what happened, and then they look like fools, right? So So that's a great change that we have in New York, and that just happened, I believe, in February of 2021. So it's recent, but long overdue. And so another way you could, increase the odds of winning your medical malpractice case is doing like freedom of information law searches. Like, for example, a nursing home may have attorney general inquiries, attorney general lawsuits against them, investigations. OPMC, the Office of Professional Medical Conduct, could sanction a doctor, or there could be a lot of different entities. So you really have to slow down and send requests into whoever is responsible and get those, because sometimes those are very, very powerful at trial. And then ultimately, like, what are the factors that determine the odds of winning versus losing? Well, they are, like we talked about, the lawyer, right, the case workup and the case presentation, whether the client, the patient, whether they're likable, whether you call a circle of friends or community witnesses to show how their life changed and tell their human story, or if they're just not likable, if they're, very bickering and arguing and they want to, out of spite, they're mad at the doctor. Jurors don't like that. So then the other important thing, of course, and one of the most important things in any case, but especially in medical malpractice, is your jury selection. When you do your voir dire and you select your jury, you have to be very careful, and you have to get their attitudes and their true beliefs about medical malpractice and suing doctors. Some people are against suing doctors. So no matter what you say to them, no matter what medical records you show them, no matter what proof or how many witnesses you call, they're just against medical negligence lawsuits. So you have to get that and do a good voir dire to get a proper jury and get those off using your cause challenges or your preemptory challenges. So that's very, very important. Venue plays a role more generally. I mean, some venues are known to be tough, like out in Long Island or Westchester, while other venues are more plaintiff friendly, like the Bronx or Brooklyn. But that's more of a general idea, because you really do have to pick the right jury. And then ultimately, your odds of winning a medical malpractice case, nobody could tell you. Like, for example, in a video like this, if you leave a comment, 2 sentences, nobody could really tell you accurately, just to be honest. You really do have to do a deep dive into the case, go through the medical records, get a detailed history from the patient, and really get that medical expert to give you their opinion. So ultimately, it's on a case-by-case basis. So I hope this has been helpful. It kind of answers the question of what are the odds of winning a medical malpractice case. Ultimately, the answer is we have to look at your case. But some of these factors are very important, like medical records, experts, jury selection, and building the right type of case in the right way. Okay, I hope this has been helpful. Let us know if you have any questions. We're here for you, and we'll talk to you soon. Have a great day, everyone. Bye-bye.